this special board meeting, the study session. I would like to call it to order, and I will have the roll call, or let the record show that all members of cabinet are present, all members of the board, with the exception of Ms. Sexton Ruiz, are present at this time, and we also have legal counsel here, who I will let introduce herself. And if we have any questions from the audience, feel free to use a white card, the request to address the board, and we can, if you have questions or comments, please send them to Hilda. Okay? And apologize us eating. This is earlier than our normal meeting time. Thanks, Dr. Boyle.
Okay. This evening I would like to introduce Susan Siegel from Gus Rosenfeld, who is providing legal counsel and information for us as far as the do's and don'ts on political activity and influencing elections. Susan?
Thank you, Dr. Boyle. My name is Susan Siegel, as Dr. Boyle said. I am not a foreigner to this district. I was at Gus Rosenfeld for a period of time as a partner and represented this district. Back in the day, I started in 1995 and then went to the Attorney General's office to advise Terry Goddard and then returned back to private practice. While I was at the Attorney General's office, I wrote the infamous guidelines that we're going to talk about tonight. And now at Gus Rosenfeld, I will tell you that I'm going to talk about some very drastic legislation that has been passed and signed by the governor and was effective on Friday the 13th, which is maybe ominous, but everything else was passed that day as well. This legislation really makes it difficult for you to advocate for passage of an election, an override, a bond, any of those types of elections. And since you have an override, capital override coming up, it's going to be very difficult. It was passed by people who don't like taxes and think that school districts have enough money, which we all know is not true. So I'm going to go over the statute a little bit with you, tell you what my thoughts are, tell you what our guidelines are, and then answer some questions that have been presented to me by the PAC from Dr. Boyle, as far as and some other questions. So let's go first to the statute. The board members have it in color, but you have it in black and white with capital letters and some crossovers. That's right. So it used to be, this statute was enacted in the late 1990s, early 2000s. It went through some changes, and the provision was that you could not do anything, the school district could not use its resources to influence the outcome of an election. However, it didn't define outcome of an election or influencing the outcome of an election. And it left some other questions open. At the same time, it directed the Attorney General to develop guidelines, which you may have in front of you, but which can be found on the Attorney General website, called Guidelines for Use of School Districts or Charter School Resources, and it's dated 2004. I helped draft those guidelines, and we think at Gus Rosenfeld that these guidelines are still in effect, notwithstanding the recent statutory changes, which I keep promising and teasing you I'm going to get to next, and I will in a moment. So the question is, how did this all come about? Well, we all know that there are people out there that don't want their taxes increased, even if it means helping our schools meet ends meet. And we know that there is a strong lobby against override elections. The 15511 was enacted to limit what school districts could do to advocate an override or a bond election. Back in the day, there were times where kids were coming home with flyers in their backpacks, telling the kids to tell their mom and dad to vote for the override. You can't do that anymore. The school district can't send anything home with their pupils. Back in the day, there was a time when you would see on the marquees, vote for the override today, and you really can't do that either. Those are district resources, and the district has his hands tied as to what it can and cannot do. Now, the new legislation did three things. The first one I'm going to tell you about is it used to be a fine of $500. Now they've increased the fine to $5,000, up to $5,000. The county attorney and the attorney general have the authority to enforce, and as you may know or may not know, Gus Rosenfeld represents quite a few school districts throughout the state, and particularly in Maricopa County. And we have at least 4 complaints that have already been filed in the last week or so. And some complaints have not been filed with the Attorney General's office, but they have been sent via letter from the Goldwater Institute to various school districts. And basically saying either take it down or else we'll complain to the county attorney. So I've spent my days the last week and this week writing the county attorney, responding to various complaints, saying that this or that isn't a violation, and the fines should not be imposed. What they did, I guess the impetus was this was something that happened at the Scottsdale School District last year, I believe, and I hadn't heard of it, during back to school night. And what the district had done is allow the pro group, the support group, rent TV monitors and then have videos running during back to school night on the TV monitors of why you should support the override, what the override was going to do. And so some people got wind of it and raised holy whatever, and holy Batman, and said this is not right, and we don't want this to go on, and this is using district resources. So bad facts make bad law, and they also make bad legislation, and this is where we are today. So the important point, let's go over some of the changes. In paragraph A, it made it clear that district resources include monies, well, I would have thought that, accounts, credit, facilities, vehicles, postage, telecommunications. Now we're talking about your phones that might be, your cell phones that might be paid for, employee cell phones that might be paid for by the district, computer hardware and software, web pages, and then the usual personnel, equipment, materials, things, or other resources, and anything of value of the school district or charter school for the purpose of influencing elections. It accepts out informational reports that present factual information, which is required under the override statute, as long as it's done in a neutral manner. The next paragraph is the one that is somewhat well, it comes out right out of the Scottsdale situation, but it's different. They modified it in the amendment process. And it says that this section does not prohibit the use of school district resources, including facilities or equipment, for government-sponsored forums or debates. Okay, we've got a government-sponsored forum or debate going on. And if the government sponsor remains impartial and the events are purely informational. That means you're going to have one side and the other side, and they'll debate as to whether the override should be passed. But it says at the last sentence, you can't rent out the public facility by a private person or entity at the same time as these government-sponsored forums or debates. Now this is important because some of the questions you have given to me to look ahead of time say, well, can we have can we rent some space? Can the pro group rent some space at the same time we have parent-teacher conferences or training or certain events? And the answer is yes, you can, because they did not address the Scottsdale situation. They went ahead and amended it. The only thing you cannot rent out is a pro group or a con group. I assume you're pros, but if you're cons in there, I will address you as well. Equal time for everybody, but you can't rent out space at the same time as a government-sponsored forum. So if you decide that you're going to have an informational night and you're going to have the pro and the con. Forget about renting out space at the same time from the outside groups to also push their position. So we go, is there any questions about that? Because I'm going to get to some other what ifs. And believe me, there are some answers I don't have. The longer I'm a lawyer, the more I learn that I don't know all the answers. First year out of law school, I thought I did, but I don't now. Okay, now let's go down to the definition of government-sponsored forum or debate. Means any event or part of an event or meeting in which the government, that's the district, is the official sponsor, which is open to the public or to invited members of the public, and whose purpose is to inform the public about an issue or proposition that's before the voters. So I represent a number of school districts. In fact, our law firm represents a number of school districts, and we have partner principal contacts. And so I have a lot of principal contact clients that are having overrides, and some of them are hotly contested. In fact, I had a board member in another district report the superintendent for violating 15.511. So that tells you the tension that's going on there in that happy family. You've got to just make sure that you follow these guidelines because of the fines and because you don't want the negative publicity. Finally, influencing the outcomes of an election. Now that's the kicker. And that's what I think is inartfully drafted, and they may have outfoxed themselves, but right now we've got to try to abide by it. It says influencing the outcomes of elections means supporting or opposing a candidate for nomination or election to public office, recall of a public officer, or supporting or opposing a ballot measure, question, or proposition, including any bond, budget, or override election, and supporting or opposing the circulation of a petition for the recall in any manner that is not impartial or neutral. Well, I wanted to ask you, how can you support and be impartial and neutral? That's what us lawyers then latch on to as void for vagueness. That's a constitutional law thing. It's what makes constitutional lawyers happy. You don't have to worry about it right now until we get to contest this statute, but I think it's unconstitutionally vague. So where does that leave us? That leaves us very afraid, very conservative, very afraid that there's going to be a violation. So the guidelines, I'm not going to go over all of them, but we are very, very conservative as to what you can or cannot do. We also don't think that this overrules the Attorney General guidelines. Now let me tell you why I'm happy about that and why I hope that any court agrees with us. In the Attorney General guidelines, after the law was changed, a lawsuit was filed by a man named John Kromko, who was a legislator, against the city of Tucson. And he alleged the city of Tucson did not fairly present a position, and he alleged that violated 15.511. And so while it dealt with the city of Tucson, that the statute that that addresses city and town elections is almost identical to the statute that applies to school districts. And it defined in the Kromko decision, let me find it, that influencing the outcome means that the communication must clearly and unmistakably present a plea for action and identify the advocated action. It does not express advocacy if reasonable minds could differ as to whether it encourages a vote for or against a candidate or encourages the reader to take some other kind of action. So we have a little leeway there, constitutional leeway. And right now I'm kind of clinging to that with dear life because I think that's less draconian than, if you will, than the guidelines that, than the recent statute that have required us to be very conservative in our guidelines. So let's go to the questions that you have posed, and then I might go back over some of the guidelines with you. Okay, should I just go down the list? First I have, can teachers have fact sheets available in their classrooms for parents who may have questions? Our answer is we recommend no, but we realize that that could be problematic. And by the way, you understand, I know this district does, other districts don't, that your fact sheets should be in Spanish as well. But I think it would be a good idea, A, to have it on your website, your fact sheet on your website, if it's purely neutral, and we're going through your fact sheet right now, and you on the at the front counter of all of your schools, so that people who come in, and your district office, so that people who come in can pick it up. They're picking it up, dropping off their kid, they can come on into the front office and pick that up. Word's going to have to spread through you all about this being available. The second one, can teachers give fact sheets to parents during parent-teacher conferences? Same answer, no. And the reason is, the teacher holds somewhat of a position of power. I mean, your kids may not think that, you may not think it, but the teacher does have some prestige and power. And giving someone, it's a captive audience, and giving someone these handouts is really going to probably be viewed as suspect. It's also going to be viewed as an audience, a captive audience, so to speak. It is ripe for challenge by somebody like the Goldwater Institute. Number 3, can PAC members, parents, hand out literature or speak about the override immediately before or after a school event that's on campus? Well, make sure the PAC members and parents are not school employees. I suggest that it should not be school employees that do that. And if you're outside the gate or in an area where any public citizen can go, you can do that. I'll give you an example. If you were a high school district and you had a football game and some of your PAC members wanted to pass out flyers or palm cards, you could do so outside the gate before people went into the gate or wherever they pass out information, even if it's inside, if you let anybody else pass out information. But I would not have any school employee do that again, even if it's on their own time. Can teachers talk about the override during their lunch break and before or after work? Well, there's informal conversation, even though you're in the lunchroom or you're in your lunch break. Sure, they can talk about that if it's on their own time or their informal break. And it's informal conversation. If they're talking about organizing at lunchtime a meeting among the teachers, the answer is no. It's just too hard to differentiate before and after school. And I think certainly if you want to have gee, I hope that override passes. I can't afford buying copying paper for my class this year. Or whatever or I hope we can get this capital override passes because we need these buildings. If it's informal and you're just having those, you have First Amendment right to speak, and you can talk about that. Number 5, can fact sheets be mailed via something like the Biltmore Prep Morning Mail? And our answer is no. Now, we debated all of these among 4 different attorneys in a meeting today who went over all of your questions. So it's not just Susan, making you angry at me tonight. It's the whole Gus Rosenfeld public law partners. So we went through these and talked about it. And the reason is the Biltmore Prep Morning Mail is targeted to an audience. And again, you're not making it available to everyone. It would be better if the pro committee makes sure that people in the district know to look at the district website for your neutral information and also what your website is. Also, if the district do you have a Facebook page?
No.
Good. Then I don't need to go there. But I was going to say, watch out for that Facebook page because people can make comments on the Facebook page and everything goes. Yes, ma'am?
But my PTO has a Facebook page, so how do we?
Is your PTO district-sponsored PTO?
It's connected with, it's our school PTO, so.
Is it a separate
It's a
501c3
501c3 separate.
Yeah, it's fine. You're fine then. If it's separate 501c3 PTO can do that. It probably would be better for your PAC to start its own, parents in support of something nice and warm and something that would induce people to want to read it. Creighton Parents or something like that. But if your PTO has one, that's fine. You can also on your PTO Facebook page put "See Parents for a Better District" or whatever you want to say. I have one district that has 6 Facebook pages, and they're all warring with each other, so that's not very nice either. Okay, now let me get the other set of questions. Check that here. Regarding advocacy, in rental of facilities, what is the definition of may not occur at the same time and place? Well, for example, APTT meeting running from 3 to 5 in classrooms and 5:15 in the gym. What if it's at the same place, I assume the same school, but at a different time? Okay, so first of all, remember what I said. This is a little different. You're not running a forum. You're doing a school activity. So you could rent space at the same time and in the same building. It's different from the government-sponsored forum. So they did not go as far as they had initially intended to do when they enacted this legislation. Yes.
So, again, the PAC could rent a space at the school when teachers were having parent meetings, and they could advocate for the election.
Right, but make sure the PAC does follow 1105 as far as liability insurance and all the other nuances of that statute for renting out a facility. Also, I hope you have a schedule of rental fees so that whatever you charge the PAC is the same and consistent with what you would charge any outside group. And you have to open it up to any outside group. So, does that answer that? Number 2, what is the definition of same place? Would different areas in the school be the same place or not? And again, you can do that, and I think different areas in the school are, I think it's irrelevant. I think you can have it at the same time, the same place, as long as you're not doing your open government forum. You're renting it out. Regarding informational materials, may a teacher in APTT meeting with parents complete the training and then mention to parents the board has called the election and refer them to Q&A materials, telling them to call the district number if they have questions? I would say no. Again, it's the captive audience, somebody of an authority. It's something that's right for advocacy on district property during district time. And remember, no matter what, we have gone through today at least 5 different PowerPoints from different school districts and at least 10 different flyers, and we have scrubbed them clean as far as advocacy goes and opinions. But there will be one. I know. As much as my name is Susan Siegel, I know that there will be one that somebody thinks, such as the Goldwater Institute or somebody else, thinks is advocacy and isn't purely neutral fact. I mean, for example, if you're an A school, or if you're an A school, or you have an A school district, is that a neutral fact? I think it is, but I think you need to be careful because putting it in the same flyer for an override implies to them that the reason you're an A school district or you have A schools or you have all these good scores is because you have passed overrides in the past. So you have to really scrub it down, and I would say no, even if it's an informational report, I would not give it to them at the APTT meeting. And then may district run informational materials for teachers to have available for parents? No, I keep that available at the front counter, and I would keep it available at the front counter here, and I keep it on your web page. I understand, given the demographics of this district, that not everybody may have access to the same internet or the same type of coverage, but you can do as much as you can to get people there and try to understand about it. Are there more questions?
Just a clarification. We are having capital override informational meetings, And we run the information to have at those meetings, and we run it in the district. Are we correct on that?
You're correct if they're purely informational and factual. I have your flyer here that our committee sliced and diced this afternoon. It's not that bad. It's a lot better than some of the others. So you know, the problem is, the question, when people ask you here's where it gets dicey. If people ask you if their taxes are going to go up and down, if they pass or it's lowered, that all depends. It depends on the general economy. It depends on what your total district valuation is. It's a combination of factors that you can't just say, oh, it won't hurt that much, or your taxes probably won't go up that much. You did do an estimate of the effect in your pamphlet, but you can't guarantee people that their taxes will go up or they will go down or whatever, because you don't know all of the facts and you can't really bring it up. Your purposes that you're going to spend the override for, I assume in your pamphlet, I'm sorry, the one thing I didn't do today was to read your pamphlet. I assume you set forth your purposes. And so you can say those. You can say, these are the purposes. These are what we're going to spend this on. Because that's what the pamphlet says you're going to spend. So I'm going to try to be a little bit more positive and tell you, what your purposes, that your purposes can be there. It's not okay to publish in your newsletter or your newspaper the pro statement that your board adopted. Even if it's reporting it as a government action, that has been struck down. So, for instance, I'm looking at a flyer and most of it's pretty okay. What will the capital override fund? You've got your purposes there, and most of them are good. And most of our statements were I don't know why they took out your bumblebee, but they took your bumblebee out down here, and they may want it to be a little bit more, I don't know, because people could interpret books or deaths or something a little differently. So I'm not the one who took the bumblebee out.
It's really gone?
Just that one. They kept this one up here. They kept the one at the top. They took out the one with the deaths and the book and the computer.
That was your bumblebee. Sorry.
Be my little baby bumblebee or something like that. Okay, and then how long does the override funding last? We suggest that you put in that it would last for 7 years and would phase down by a third in the 6th and 7th year. That way you're completing the picture. Actually, that helps you, because you can explain to them it's not always going to be the same amount for the full 7 years.
Is that true of capital overrides? I know it is with an M&O override.
Yeah, I don't.
Mr. Wallman's here.
Yeah.
Mr. Wallmer, the question is, with the capital override, does it phase down in year 6 and 7?
No,
It does not.
but you've got it in your flyer. No, I guess you don't. I'm sorry. They added it. No, you're fine. I'm
Okay, so
sorry.
we don't need to add
You
that.
caught me off my
Okay.
guard. I'm sorry. I blame somebody else, but I'm the one who repeated it, so I'm in trouble. Then the one statement that I would keep out is, without appropriate funding, this puts our teachers and students at a disadvantage. However, social studies materials are newest, having been purchased in 2011. Reading materials are oldest, dating from probably the social studies materials are newest and the reading materials are oldest. That's fine, but not the sentence before them. So I think you're okay. The proposed, you're pretty much okay for most of these. I'll give them to you. But I wanted to correct this out.
We can make a copy. Can I go back to the question that was asked? May the district run informational materials, the same that we pass out at our community meetings, to be available to parents? So it's this cleaned up. Can we do that using paper and machine.
Yes, you may, as long as they're purely neutral.
And we can have those materials available when parents come in to APT meetings, as long as it's not in the classroom, but could be at a rented space or a table where parents.
The rented space could have it, although I would think they'd want something a little bit more
Yeah.
jazzy. Maybe they can have the bumblebee back in there, you know. But the rented space would be okay, but you could have it there, when they come in and, I guess, when they
And we
sign
can
in.
reproduce those
Yes.
materials because we're taking them to information.
And because they're purely informational.
Okay, that's good to know.
Susan, I've got a question. So if the PAC, using their resources of time, energy, and talents, created materials, are they able to, say, put flyers into like teachers' mailboxes to distribute information to staff? And I think some of the questions are really clarifying what staff can't and can't do in terms of when they're representing themselves as an employee of the district versus themselves as a member of the community or a concerned constituent, or obviously you mentioned briefly that everyone still has their own First Amendment rights, and we do have a constitution that allows people to voice their opinions. But I know that there's some now, especially with the heightened fear of the added, fine. I think people are a little nervous about where their lines are in terms of some of the do's and don'ts for staff.
So, I think there's two parts to your question, so I will try to answer them both. The first is, can members of the PAC put materials in mailboxes? And the first is, I think it would be safer if the members of the PAC that do that. The answer is yes, maybe. I'll tell you why. If your mailboxes are open to anybody putting things in, if you're having a baby shower for somebody, a teacher in the school, and you put in the little baby shower in, if anybody can put something in the mailbox for the teacher, then that's okay. That's fair game to put it in there. If, in fact, the person that's putting them in, it would be better if they weren't school district employees. It would be better if they were
A PAC.
PAC member that is not an employee. I assume you've got some PAC members that are employees too, though. So, because it's just so hard to identify whether you're on your own time or you're not on your own time and who's doing what. And I have a situation right now where 2 employees were meeting on their own time, but now the county attorney wants them to document that they were on their own time. And with people that are professional and don't have a timesheet, it's hard to do sometimes. So the answer is yes, you could put them in mailboxes, and that's in the guidelines, the Attorney General guidelines, and we think that's still applicable. And if that mailbox is open to the public. Now, there's some other nuances to that, and that is.
Could I ask a clarifying question? Who would that material be for the staff?
For the staff.
Just for the staff?
Yes, not to distribute to students, not to distribute to parents, but just truly staff information.
Yeah, the big no-no, the biggest no-no on here is delivering it to students. Yes.
So I would take that as a PTO member. I have gone and, because I'm allowed on campus, I have gone and put invitations into teachers' mailboxes for things. So that's something as a parent and a PTO member I would be allowed to do.
Yes.
Then.
Yes. Voter registration, I don't think you do that anymore at this district, do you? Or do you have it available? You used to for a
On our
while.
website, we always have a link, and we've had it there for forever before the election was called.
So you're okay.
So we've had that link before the election was called.
Okay. Private vehicles, if you have if you can afford to have bumper stickers, you can have, it's not a violation if you have private vehicles parked out there that say, vote yes on override. We need your vote, that type of stuff. I don't know how you're getting the names of your parents. You have how do you have a phone bank, or how do you get the names? Through the PTO or PTA? Get out the vote. I don't know what you're going to be doing in that regard.
Yeah, happy
But-
to talk some there. Occasionally, we have a presence on campus where we have leased some space at the end of the school day. I'd love to have your opinion there on the legality of that activity with new legislation. We may lease some space and contact parents in the pickup line as they come in and off campus, and ask for phone numbers, get them to take an informational sheet, that type of thing.
As long as you lease it, and you lease it according to the facilities use agreement, you know, you can ask, and parents come up and they want to know, you know, that, you can do that.
Okay. Elsewhere, we've done an information exchange with PTOs to get parent contacts, that type of thing. So,
Okay, good, good. Because really, the district can't generate and pass out anything, you know, you pretty much have to,
right.
you're on your own, and you should probably keep a good list of that, because since you are an elementary district, you may have some parents that are here for 8 years or more, and keep it for the next election too. Pass on your information.
Is that information that would be available if we did a public information request, or are they not allowed?
No, well, the short answer is no, because the long answer is if your district defined directory information as parents' addresses, but I don't think you do that, do you? Parents' names, what's your, under FERPA, no, your directory information doesn't give addresses.
No.
And hardly anybody does. So if your directory information gave addresses, you could do it that way, but since it doesn't, you can't really do it.
Can an individual school PTO, with parent permission, develop a directory?
Yes, the question is, can an individual school PTO? Now, if the PTOs are separately 501c3 separate entities, they can on their own develop it. And I know that just birthday party invitations and things like that, you can kind of develop a little phone tree that way, and maybe even already have one for each classroom. It's been a while since my son was in school, but or in elementary school, but I seem to recall that phone trees were a big thing. And so if you have those, then you can use those phone trees. It's really, because of this law, PTOs and whatever the organizational structure is are really important because they are separately incorporated or separately organized, and they are the ones, they are the backbone of passing your election. So yes, they can do that way.
I would encourage anyone who has a question to ask it.
Yes, sir.
You said a group that's presenting neutral information can present it at the same time as a school event. Is it okay if, say, maybe to get to APTT night, they have to all walk through the library? Could you lease the library then, so essentially everyone has to walk by you as you present the information?
Yeah, I think so. I mean, it sounds to me that might be frowned upon as kind of a little manipulative.
Handed, like.
Yeah, and I don't want to be there defending you when you in front of the county attorney. So I'd be cautious as to how they have to go by you and all that. You can do that. But back to do you have if you have an organized con group, do you have an organized con? Not you're aware of. Well, I don't know they're going to have this debate or things. Some districts, there's a big, as you know from reading in the newspaper, a lot of overrides failed last November, and some districts have an organized con group, and so that's when you have the two debates. If you don't have an organized con group, you wouldn't have a debate because you have to have somebody speak against it. I don't know, in your pamphlets, did you have somebody that showed up with a con statement?
I don't think so.
Really? Okay. Well, I guess you won't be having any debates. So, yes.
Back to your discussion of bumper stickers on private vehicles in the parking lot. Maybe you can expand on that a little bit, because it seems like that could be taken to some degree of absurdity, and do you think there's legal license there to go to absurd extremes? I could see magnet signs on every car in the parking lot, which would be kind of overwhelming presence in the parking lot.
Yes. Let me tell you what the AG says. For example, parents, teachers, and others visiting the school on school business or to vote on election day could park vehicles with bumper stickers in the school lot. On the other hand, a school may not permit the school parking lot to be used to permanently park a vehicle displaying a canvas signs in the lot during election cycle, when the owner of the vehicle is not visiting the school for school business or other permitted activities. So, if, you know, I remember going by all these ugly swap meets along the highway, and, you know, they have this big old truck, this is swap meet here on Saturday. You can't do that. But you could, you know, if you had business inside the district, or if you're a teacher, and you're going to be there for 8 hours, you could park your car with a big sign that says, you know, vote blah, blah, blah. That's what the AG's guidelines say. If the school is a polling place, you know the whole polling place thing. You have to be away from there. In that regard. Yes, ma'am.
Clarify one more time, the debate thing and the pro and con. So if we don't have a con, it sounds like we have a little more leeway as far
No,
as.
the way that, I'm sorry, the way the statute is now, you need to have a con. You need to go out, maybe rent a con. And I didn't really mean that seriously. You're supposed to have both sides presented. I don't know, maybe you could get one of you to present the other side, I don't know. But you need to have that in order.
Gotcha.
But that is a good, the debates are a good way to get your message across to the public as to what you're there for and what the voter rights for.
So can I, just to make sure I'm synthesize, so there's two distinct different activities. One is a government-sponsored debate that includes a pro and con discussion for which a PAC cannot rent space at that time.
Correct.
The other is a PAC renting space at a school or district facility using our rental agreement and going through that process and providing information to whomever's there. That might be parents, that might be teachers, administrators, and they're able to do that because it isn't a debate setup, it's a separate activity.
Correct.
Am I understanding that correctly?
You are correct.
So two separate.
You are. And
And
that's,
just to follow up on that, so like a school district or a school site could then sponsor a debate at their site. Like that's something as a government entity they could sponsor, correct?
yes, you could.
And they could invite parents from their contact to date, like they could use their dialer and say, come see this debate at our school site.
Correct.
Okay.
It has to be perfectly neutral as far as the school district's part. And then you have somebody speaking for and what somebody speaking against. So, trying to think if there's any others that are dicey. And there's always dicey. The kicker is for employees off-duty time and making it very clear that their presence is off-duty, you know, that they are there in their individual capacities. Board members, you aren't treated as starkly as employees are, although it says people who aid, it. But you can say, I'm here, I'm so-and-so, I'm a board member, but I'm here in my individual capacity to urge you to do this or that. So if you go and, you're all leaders, if you go, you have to say, I'm here as in my individual capacity, because you are not acting on behalf of the board. The board hasn't authorized it.
So in terms of back to the teachers, given their the nature of the profession and the fact that they don't clock in and out of their classrooms. So a couple hypotheticals. So we're at a barbecue on the weekend and we're having a conversation with people who live in our community. And somebody asks the question, hey, what's this deal about the override? A teacher using their First Amendment right to free speech and they're not on the clock and they're clearly not working could have a conversation about the override at a barbecue, at happy hour, at someplace off campus where somebody is engaging them in a discussion and they are not liable to be sanctioned according to the statute.
That's correct. And so, if you have a community function or just a social function, teachers should not be afraid of speaking their mind and their opinions. And that word needs to get out if it's on their own personal time. And, some of them I think, are intimidated by this, especially with the $5,000 fine. But you're right, they can speak their own. And the fact of the matter is that I know as an attorney, I get at least 10 calls every November wanting to know which judge people should vote for or vote down. I'm saying they're all okay, you know? And it's the same thing with you, with the teachers. They're going to be asked by their neighbors, you know, is this really true? Do you really need this? Come on, you know, do you really need these books or these whatever you're asking for? Yes. I'm going to go over the 5 questions on page 5 of our handout. Okay, can a district employee present information about the election to a meeting in support of or in opposition? Yes. Acting in his or her capacity may present in a manner that's impartial and neutral factual information. An employee during non-duty time and acting as a private citizen may freely participate in such meetings and freely express his or her opinions. Any employee doing so should make clear that they are not speaking on behalf of the district. That's just what I told you about. Can the district allow groups in support of or in opposition to election to meet in district facilities? Yes. You may rent or even permit the uncompensated use on the same basis as conditions to other groups. However, such use may not occur at the same time and place as a district-sponsored forum or debate, which is what we talked about. And you're not denying anybody any use. So I don't think it'll happen to you, but we lawyers are hired to think of all horrible scenarios. So, but I don't think you'll have that, and I'm not going to bring that up. What if I'm asked if I support the election and asked how I will vote, and you're an employee? Well, an employee acting in his or her capacity as a district employee can factually answer whether he or she supports the election and how they intend to vote. That's their First Amendment right. However, an employee acting in his or her capacity should not attempt to influence how other people vote. You can say, I'm going to vote for it, period, end of story. Not, I'm not going to vote for it, you should too, because our children's lives are at stake, or whatever you say, which is of the truth, but you should not try to influence it.
Can I interrupt just to see if I have your handout that you're going over, or if I need to? I have one that is
In color.
the law. I have the guidelines from the AZ Attorney General's office that you wrote. Okay, so it's the one that says Gus Rosenfeld.
And that is hot off. If you see down at the bottom, 9/17/2013.
Yes, I'm sorry, what page?
I'm looking on page 5.
Okay, that's why. Thank you.
And this one's kind of dicey. This is something for your employees. What if I receive an email on my district computer advocating support of the election? What should I do? So an employee is not prohibited from receiving such an email. However, you can't generate or forward such materials. The best practice would be to delete the email and without replying or forwarding it. Likewise, if such advocacy appears on the district's Facebook page, you don't have one, so we're not going to go into that. But teachers should not comment.
Could the employee forward it to their home
Yes,
email address? Okay, so they could forward it to themselves.
yes, they could.
Thank you.
And the other thing, I think it's okay because I've advised the districts on this one. I think it's okay to write back to somebody saying thank you. As you know, this is a district computer. If you need to communicate with me, please communicate with me on my private email. That way, you've got the whole sort of issue wrapped up. They know what your new email is or your home email is, and can do that. And you've made it clear, and you've backed it up. Can I make a contribution to a political action committee? Absolutely. An employee during non-duty time and acting as a private citizen may make a contribution to any PAC.
I have a question back to the debates. Now, if a debate was to take place in the school, and seeing that it's got the pros and the cons in the debate, would at that point it be okay for flyers about the debate to go home in the kids' backpacks, since it's both ways?
Yes, I assume that, yes. It's impartial, I think that's fine, yes. I think that if it's a, they seem to be supporting a neutral debate. We're having a neutral, impartial debate, presenting both sides of the capital override. Please come. Yes.
Susan, what's your perspective on liability and recording one of these events and making it available? Because that's something I could see us doing as the PAC as a YouTube asset, et cetera. But, you know, at the same time, I'm somewhat concerned about the liability associated with Scottsdale video presentation of their.
Well, I think Scottsdale's problem was when they presented it. I think you could record, I think it would be okay, for example, if you recorded one of these events and put it on your, on YouTube and posted the link in one of your Facebook pages. Likewise, if the district wanted to record a neutral debate and put it on its website, it could do that as well. But I think where Scottsdale got in trouble was and it wasn't, they didn't find it as a violation, just it invoked some draconian measures as a result. And so where Scottsdale they looked askance at, not Scottsdale, but the cons, was that they were, you know, basically running this video nonstop, why you should pass your override.
Yeah, one more. So would it be appropriate for the district to inform district personnel that if they should receive communication from the PAC, that they recommend that the district personnel forward that email to their home account and respond to, if they wish to stay informed from the PAC? Would that be appropriate guidelines for staff?
Respond at home on their own
Right,
account.
respond from
Yes,
their home account.
using their own account.
To stay in touch with the PAC. Would that be appropriate?
I wouldn't say to stay in touch. I'd just say you can forward that to home. Period. End of story. Any further any further contact with the PAC should be on your own time, on your own account. I wouldn't say it in any way that would encourage people to respond. It would just be, if you want to, that's the way you should do it.
Okay. Thanks.
Susan, do you think that there's any concern with PAC materials referencing back to the district's factual information on the webpage? So as an example, if it said for more information visit, you know, www.creightonschools, because that's where the factual information is, or would you recommend that they really be separate?
No, I think the PAC can say, if you want neutral information, you can see it on the district's website. You know, and also read your pamphlet, you know, when it comes in the mail. You know, I think that anything that's neutral, I think the PAC can refer to. Anybody else? Yes.
For places like libraries, community centers, things like that, can we distribute flyers there, or what is the law on that?
You'll have to, well, cities and towns have their own, they can't do it either. I mean, they have so if it's a library that's owned by the city, and they are, they will tell you no, they can't do it under there's a statute that deals directly with libraries, so they can't. If it's you know, if it's publicly owned, city-owned or county-owned, you're really you're restricted. You have to go. You have churches. Churches can do that because they're not. They're off there, and those are the best. Those are the only places I can think of as far as community gatherings that would permit it. But no, libraries will tell you no. We used to post the. In fact, I remember going down to the Phoenix Public Library for this district and posting a big ad. You know, when we used to do the ad for an election, notice of the election at Phoenix Public Library, but they don't allow that anymore. Probably because of the statute. Okay. All right. Well,
thank you
good
so
luck.
much. That's really been super helpful. Thank
I
you.
hope so. All right. Thank you.
Thank you. I'm going to, do I just adjourn this, Hilda? I don't need a motion. So I'm going to adjourn this meeting. And since it's 6:58, I am going to